Excuse me, my throat is hurting me a little bit. Welcome once again, and I appreciate everybody taking the time. I know December is always difficult, but this subject matter today has been very dear to me, and I'm so honored today to have these two great speakers. But first, I just want to say thank you to everyone attending once again the KoreSummit Webinar Series for 2023. This is the last one for the year. Stay tuned, 2024 schedule is coming out soon. I want to thank our sponsors. Without their support and helping us bring this vital education to you, it wouldn't be possible. Thank you, Nuvei. If you don't know much about Nuvei, it's a payment processor, one of the third largest in the world, in over 180 countries. And of course, thank you to KoreConX as well for their initiative. So today we are having a phenomenal discussion. Some of you are wondering, like, 12G, what the heck is going on? And interesting enough, I know this was brought up 10 years ago, 6 years ago and all that, and it got dismissed this side. And we're going to have a great discussion about has 12G kicked in? And I want to give the honor of the title to who came up with it, Sara Hanks. So
it's a terrible
No, it's a good title. It caught everybody's attention. So before we get started today, if you could take a moment, Sara, please introduce yourself, and then we'll move into you, Patrick. Thank you.
All right. Hi, Sara Hanks. I'm CEO of CrowdCheck Inc. and managing partner of CrowdCheck Law. And between the two of them, we provide a wide range of legal disclosure, diligence, compliance, and filing services for all of the online exemptions, Reg CF, Reg A, and Reg D.
I'm Patrick Costello. I'm an attorney at the Bevilacqua Law Firm. There, we handle a wide range of securities issues, securities offerings, Exchange Act reporting matters, in general corporate governance and contract, and transactional matters as well.
Good to have you, Patrick, and looking forward to listening to you speak today. This is a great discussion, two ex-SEC lawyers, and the hot subject today is 12G. So, but before we start digging into a lot of the items and all that, Sara, why don't you kick us off and just give us the overview? What is 12G? What is this regulation or rule that we need to be aware of?
Okay, so Section 12G is a statutory provision, and that's important because it's in the statute and the SEC can't change it, although they can tweak various bits of it, as we'll get into it. But it's a section of the securities laws that say, in the event that you end up with more than a specific amount of assets and a specific number of shareholders, you now have to become a fully reporting company with the SEC, a company that files 10Ks and 10Qs and proxies and Section 16 disclosure about all of your investors, and all of your investors, big investors, have to file. So this is a huge thing, and it is a thing that you do not want to be caught by mistake to sort of wander in and go, oh my goodness, 12G has kicked in. But the thresholds are at the end of your fiscal year, do you have assets, gross assets, not net assets, just gross assets of $10 million, and do you have more than 2,000 holders of record of a class of securities, or more than 500 non-accredited holders of record of a class of securities. And that 500 is the one that is causing some problem in the online exemptions, where a few companies have suddenly realized at the end of the year, oh my goodness, we've got too many shareholders and we've got too many assets, and now we're supposed to be a registered company, and we can get into what that means. I don't know, Oscar, if you want me to go into the various conditional exemptions yet, or...
Yeah, we'll get into that. But thank you for the great start. You talked about what 12G is and the threshold. Patrick, why don't you come in and let's talk about the reporting requirement, because then after that, let's move into the exemptions, Sara. Because I want people to be able to walk through in different categories. So here's the threshold. What are the reporting requirements, Patrick?
So if you trigger the 12G threshold, you become a Section 15 reporting company and a Section 16 reporting company. Section 15, like Sarah said, are your 10Ks, your 10Qs, your 8Ks, the quarterlies, the annuals, and then the periodic reports that you would need to make as a public company. And Section 16 is for corporate insiders and holders of more than 10% shareholders, where they need to disclose transactions. It's a very tedious area of the law, making sure that you go through and capture all of those transactions. Interestingly enough, it's not a you don't become a Section 13 reporting company, which is for I think, or I could be wrong. Maybe Sarah, you can correct me if I'm wrong about that.
I think basically I always think of it in terms of Section 12 itself, as opposed to the 15 or 13. But there's there are several different ways of triggering those requirements, as we pointed out.
And you can do it purposefully and inadvertently, like we said. And I think one of the more interesting facts about 12G is that once you file the registration statement, it goes effective automatically after 60 days. And that can happen with or without SEC review. Now, they usually don't. I mean, in my experience at the SEC, so I was an examiner, they would do what they could to not let those get to 60 days. I didn't see it happen, but I don't think that was always the case.
So can I ask you something? Because I always feel like there's a fear by people. Oh my God, I got to do this. What is that reporting requirement and some of the specifics? So financial reporting is one, right? Annual or quarterlies?
Both.
So quarterly statement, annual statements, outside of the financial, what other reporting is it that is, it seems like some people get so scared of? What is the other onerous element to it?
Well, you're going to have to make the types of disclosures that you would make if you were filing or updating a registration statement, an IPO, a registration statement on Form S1. You're going to have your business sections, your risk factors, your beneficial owners, your related party transactions, your MD&A sections as well. These are all sections of registration statements that can cost a lot of money and time and effort to make sure are in compliance with the federal securities laws. And, I think since everyone here is watching these videos, I'm pretty sure that they all know that if you don't comply with those securities laws, it's not a good thing. Then if you're going to go around and accidentally end up, breaking or violating Section 10b-5, you may find yourself with, a very costly mistake, or an omission, making a material omission that you didn't mean to make, can even compound those costs.
Yeah. Okay. And to build on what Patrick was saying, I mean the cost, especially in terms of accounting, because a lot of people are going to be coming to this and going, well, I'm a Reg A ongoing reporting company, and how bad can it be? Well, I mean, start with the fact that you now need PCAOB accounts, and your audited financial statements have got to be audited in accordance with PCAOB rules. So there will be a deeper dive, and there will be more expense in that. And then you've also got all of the things like the ongoing reporting. If you don't file on the due date, then you're going to have to file make a filing saying we're not going to make it, and then you'll have to update it. And in the meantime, you're in this sort of regulatory limbo. It's very much different than Reg A. I mean, some of the things Patrick mentioned, MD&A. It's a lot different for in a 10K than it is in a 1K or a 1A, the Reg A forms, and a huge amount different than it would be in a Reg CF. Because you are not going to just have to say, well, here's our revenue. You are going to have to break it down into a huge amount of granularity. You are going to have to decide if you have segments, and there's new accounting rules with respect to segment disclosure, and segments is business lines. We don't do that in Reg A. We don't say, well, some of our things are services and some of our things are ongoing subscriptions. You have to do that for the registered. So, Oscar, people should be somewhat, just a tiny bit terrified, and not.
Oh no, I'm
pondering into
already
this.
terrified. Yeah, you and we're leading to this. I mean, I wanted
Yeah.
everybody to understand what it is. I think there's a lot of misconceptions. Number two, some people, oh, I can handle that. But I think Patrick said it best. These are very costly things to do. The financials, you're already doing that. But doing an MD&A the right way, you may find yourself that you're walking down a path that may not be suited for you. But like I said, if people want to go down that route, at least now you know. Let's talk a little bit now, Sarah, about the exemptions. So obviously, there's a number of exemptions that are under Rule 12G. Let's talk about some of those and how they apply, and then we're gonna go into some of the things that we couldn't talk about a few years ago because they weren't there yet. Today they are, and now we got to deal with them.
Right. Yeah. So one of the whole confusing things about 12G, and I'm going to put the starting point. Remember I said holders, shareholders? It's not necessarily just shareholders. It could be the manner of holding is really important. So if you hold directly on the company's books, if there's a KoreConX transfer agent entry that says Sara Hanks, that is one holder. But if I were to choose to hold through Morgan Stanley, my broker-dealer, Morgan Stanley could hold whole bunches of people. He could have my account and Oscar's account and Patrick's account, and that they would hold in street name, and that would be one holder. So that's just bear in mind when I talk about holders or shareholders, that's what I'm talking about. And we're going to talk later about some of the changes that the SEC might make in this area. So going back to the conditional exemptions, two different ones, completely different.
Okay.
There's a different one for Reg A and a different one for Reg CF.
One for Reg CF.
And if you have made an offering of both Reg A and Reg CF, which many of our clients have, then you are going to have to keep count and monitor both of these. So conditional exemption from 12G for Reg CF says if you are making, you are compliant with your ongoing reporting and you use a transfer agent such as KoreConX, and your net assets are less than 25 million. Assets are less than 25 million. Then you do not count the people who acquired the Reg CF securities and the people that they sold to. So the exemption goes with the shares, not with the people. So you don't count shares originally issued under Reg CF in that holder count that I mentioned, so long as you meet those three exemptions. If you've sold shares under Reg A, even if it's the same class of shares as the Reg CF ones, then you have to meet slightly different set of conditional exemptions, which is your Reg A filings have got to be compliant, you've got to use a transfer agent, and you can't have a public float of more than 75 million, or if you don't have a public float of that class of shares, can't have revenues of more than 50 million. Now, going back to the what does it mean to have a public float? There was always this assumption that all of these shares would trade. Most of them aren't. Public float is generally defined as shares held by non-affiliates of the issuer times the price in their primary market. And we take the view, and I'm sure Bevilacqua takes the same view, which is if there isn't a primary market, then you haven't triggered that. But if those shares are traded in some kind of market, you are going to have to keep an eye on that 75 million. And if the company has raised 75 million last year and 75 million this year, oops, they've just fallen outside the exemption. So that's as we get to more robust or buoyant trading, when there's more liquidity in Reg A, that's going to possibly kick in.
I can already see that. I can already see my brain is already tickling. But something you said that I just want to make sure I'm clear, if nobody else, when you first started describing the what triggered 12G, you said 10 million in assets. And now with the exemption is 25. So as long as I'm using these exemptions, Reg A or Reg CF, it got increased to 25 million. So that's a blessing.
Yeah.
It got increased. Okay.
Yeah. There's an interesting story there, which I think has a really good moral, is when the proposal was first made for Reg CF, the proposal included permanently excluding. You do not ever count the shares issued under Reg CF, either in the initial issuance or as they are sold and traded. And those of us who read through all of the proposal were like, oh, well, that's a good idea. Love that. That's exactly how it should be. We did not comment and say, yes, that is a good thing. Many people or several people commented and said, no, this should not be permanent. It should be conditional. And the SEC looked and said, well, nobody said it's good. And 6 people have said it's bad. So they made it conditional. And when I complained to the SEC, they said, if you like something, say it. So whenever you're doing a comment on an SEC proposal, even if it's exactly as you want it to be, say that is exactly as it should be. So it's the it's the sort of compromise for, well, 10 million is sort of too much, so we're going to expand. But my view is you always start with that 12G. Always start. If you don't have the assets, then you don't need to take the next step.
Right.
Okay. So let's so 5 years ago, 6 years ago, and I look back, I know you brought it up before, and I'm sure Patrick at the SEC you saw it, or even people talk about it. Today, I think most intimate, I don't need to worry about that. What's the likelihood that'll ever happen to my company that quickly? Or my favorite one, I'll deal with it when it comes. So let's start with the scenario number one. I'm going to use Reg A and Reg CF, and I know look, even internally in our team, they go, Oscar, why all of a sudden are you talking about it's okay to do SPVs and custodial? Because if I look at the long journey of this company is going to be worth more. It's going to be raising more capital. We have to see that this is going to, we have to prevent it, right? So let's talk about that. Let's talk about what can companies do or think about as they're planning their capital strategy, because I don't think people have done that. And now 12G needs to be there. There's now clear evidence, and we can't tell you the company names, of course, but there is clear evidence, companies who have met this roadblock, and they're at that last, what is it? They have 2 years to make their decision, right?
They have 2 years so long as they are up to date with their filings. If any of their filings are actually late, even by 4 days, they are now thrown into 120 days.
A lot of pressure.
Yeah.
Pressure.
Yeah. And we have had this exact conversation with the SEC, and we said, come on, 4 days. And they're like, rule says what it says. You got 6 months.
And assumingly you would be on top of it, right?
But I remember. Look, Patrick, Sarah and I, and all of us, and it's great to have you join us in our summits. But I know that 12G's come up before, and here's how it's come. Oh yeah, you got to be careful with Rule 12G, and then we go next. Let's talk about the capital raising. Right. I have a different mindset now, and the different mindset is because I'm seeing the level of companies that are coming on. They're more robust. They're not startups anymore. They're not startups. They have big assets, real estate, and all that. And we can all jump in and, hey, let's get the filing done and let's do the race, and woo, everybody's happy. But then we have to deal with the consequence of this client who wasn't given proper guidance. So this is the guidance that I'm talking about now, that I think certain companies need to really think about it. It doesn't change the offering that much, but it does change kind of how the investors will be managed going forward. And if it's done properly at the beginning, I think it's better for them and it doesn't change what we're trying to achieve. Am I correct on this? Patrick, have you run into this yet? Are you advising clients ahead of the schedule, or are you just going into the filing element?
I think that obviously business planning, getting, and especially if the client is coming to us with their idea, right, with the thing that they want to do, the very early on in their the life of their business, it's definitely a lot easier to plan around that. There are obviously things with Reg CF that you can do with co-issuer offerings, which I've had a hand in, and one of the interesting things about them is that of the shareholders who invest in a co-issuer crowdfunding vehicle, those shares are treated as held by one single person, if they're natural people. So like me and you, Oscar. Now, if they're corporations, it's still a benefit. The corporations are treated as separate from the the Reg CF special purpose vehicle, the investment vehicle. So if you had two corporations investing in your co-issuer offering and 100 100 natural persons, that would count as 3 holders of record under Section 12G, which I think, especially with what the SEC has done with Rule 389 and the exemption from the Investment Company Act, I think that opens a lot of doors for issuers to raise even more money and get even more capital without having to worry as much. Now, it's still obviously a worry, right? And it's like you said, it's something you need to plan for at the beginning, and it's definitely something that we advise our clients on from the start.
Sarah.
Yeah, I'd just add a couple of things about the SPV that we've been talking about. I mean, this was, as you know, introduced in 2021. Did not exist before, and that's why we're seeing some of the early Reg CF companies are getting caught by 12G. Whereas if they had used SPVs, which was not permitted up to that point, because as Patrick says, that vehicle would have triggered Investment Company Act concerns, and you can't use investment companies in Reg CF. So yeah, you can, if you use an SPV, then specifically it does not count for 12G, and you can use it in order to not be subject to 12G, because we'll get to that issue with custodians in a second. And so you can blatantly say, we are doing this in order not to have to become fully registered before our time. Some of the tricks with the SPVs is, as Patrick says, they are co-issuers. So you need financial statements for the actual issuer and the SPV. And I know it is a huge pain, and I know you're basically going to be auditing zero. Still, that's what the rules say. There are severe doubts about whether you can use Series LLC for these things. Apparently, FINRA has said no, but has not publicized that position. Sadly, please, FINRA, do that. And then the other thing to bear in mind is you may need a whole series of SPVs. If you're coming back every year with different prices, you're probably not going to be able to reuse the first SPV. So you can have SPV 2022, SPV 2023, and it's really, is there a separate entity there? Not really, but you do have to go through those requirements. And annual filings for both entities, the issuer and the SPV, and any subsequent SPVs. Again, financial statements, and people could say, well, why do we care? It's because you care that the SPV actually owns what you say it owns, which is the shares of the underlying issuer. So it's been a great improvement, but it is not it's not completely uncomplicated.
It's not uncomplicated, but at least it seems to me that discussion now needs to happen more often, because I think it's almost I don't know what the legal ramification are, where people say, well, you never told me. I know I walked you through it. You said it was okay. I'm just playing devil's advocate, a CEO who gets all raffled up, I'll get that lawyer. And I'm seriously, I'm almost like, one of the things I'm thinking is, okay, I made you aware of 12G. You understand that okay, great, sign here. Thank you. I'm doing that right now with clients who say, I don't have 300 shareholders in my Reg A. Okay, give me a document, sign it, get your lawyer. I just see it as a protection, because it's starting to happen more and more. The one thing we always have to remember about a venture is that we're doing it for explosive growth. Right. And if your projections are correctly, and they do happen, that's sooner rather than later happened. And now you have to deal with it in a very fast way that it's going to be very costly, either way, going the routes. So let me ask you a few questions just to make sure I'm clear. So when a company is raising capital in Reg CF, would it be beneficial to right off the bat say, you know what, this is a great model, great, we're just going to put everybody in SPV. There's a little bit of additional cost, but this way we never have to worry about it going forward. Is that worth it, or does it still require more detailed information?
Sarah. I think there's a trade-off, right? Or Sarah, sorry, sure. if you wanted to
No, go ahead.
I think there's a trade-off in that, like we just mentioned, it can be more work. There are more compliance costs, and the rules, Rule 389 as it's written, you can't really extract extra money for as manager managing that SPV, right? Because one of the requirements is that it doesn't that it doesn't pay any fees, or it can't take out any loans. It's a specific entity formed for a specific reason, and for certain companies, it may not be beneficial. One of the situations where I've seen it be a interesting and kind of exciting opportunity for issuers is with real estate companies involved in purchasing, investing in real estate, or construction and industries like that, because institutional investors in that industry, they can be finicky. They don't like investing alongside non-institutional, non-accredited investors, right? So by having these SPVs, you're aggregating all of those non-institutional, non-accredited investors into a single entity, so that if you have potential institutional funds who would like to invest in your business, they won't be scared off by being on the balance sheet with those other investors. So it opens up opportunities in that route.
Yeah, it's interesting because we see this a lot where people say, it solves the messy cap table problem. It kind of doesn't. It's sort of form over substance, because you are not investing on the same line item as your 500 crowd, but underneath the SPV you have exactly the same issue. So it really does, but to the extent it makes a company more attractive because the VCs or institutional investors don't really understand it, fine. The problem is that VCs are so used to Reg D type SPVs, where you've gathered them all up, and the decisions, you are saying here, this is how it's going to be run, this SPV. So you're giving the decision to one. You're not going to run into the messy democracy that is still there if you have a Reg CF SPV, because the SPV is required to pass through all of the economic rights and all of the governance rights. So if you've got voting in the shares, the voting goes all the way through, and you do not have the ability, and we can argue about the whole lead investor issue, but you do not have the ability to say no, you don't pass those governance rights on. So it is kind of illusory. But to go back to Oscar's question, I mean, we generally say if you're an operating company, for a lot of LLCs, probably not worth it. For collectibles and the like, probably not worth it. Small artistic, we're seeing some movies and things, not necessarily going to, they're probably not going to have a 12G problem. But for a regular operating company, especially a high-tech, high-growth company, we generally say this is a good idea.
Yeah, and the whole idea of venture capital being scared off by the cap table, that's a 10-year-old argument.
They are
that's
such
dead.
Wimps. They're scared of everything. We're scared of the crowd.
Well, they're going to be reporting like everybody else now. So welcome to our world. For me, it wasn't really about the VC. It's really about helping companies, and as you said, any operating entity. This is something you need to consider. That means you're operating, you're generating revenue. That means you have a higher chance of getting to that threshold that 12G can potentially kick in for your company. So obviously, the SPV is one model. The other model that a company can consider as well is called the custodian model. And the custodian model has been very messy to date. Obviously, we're not going to go into the technical components, but there are companies working in solving this issue. But let's talk about the custodial model versus the SPV. You want to go at it, Patrick? I mean, have you had experience with the custodial model in particular?
Not as much, but as I understand it, has something to do with shares that are held in a street name can count as a single record holder. Is that right?
You nailed it. You nailed it. That's the simplicity of it, Sarah.
Yeah, that's it. I mean, it's if you have shares that are held in the broker's name and street name, that's one method. Or you could have a traditional custodian. And I've had the conversation way back when with the SEC about, can we treat, for example, transfer agents as custodians? And they're like, it's got to be what we traditionally understand as a custodian. So, providing that that you do have somebody who is like XYZ Bank Custody Solutions, that would be a custodian. But the one thing here is, and I foreshadowed earlier the fact that the SEC is thinking about this area. But as the rules stand at the moment, anything that is held through a custody structure, whether it's a bank, a financial institution, a traditional custodian, then those shares are counted as one holder of record. The one thing I would flag here is, in general, you do not want to be saying that this is always going to be a solution to 12G. Sorry. Because that starts to look like evasion of 12G and as opposed to avoidance, and we do not want to have evasion. So there's a kind of mushy area here. But as things stand, I mean, there are so many reasons why you want to use a custodian. There's the practicality, the communications, the logistics. If you've got a custodian, it is a sort of side benefit that you have the 12G treatment of as one holder of record. But just bear in mind the thing I mentioned about the SEC and changing the rules. The top two things on the SEC's regulatory flexibility agenda, which comes out twice a year, came out recently. Reconsidering the definition of holder of records, still there, been there a couple of years. Over the years, at times the SEC has said, yes, we're going to change it. No, we're not going to touch it at all. Just bear in mind that they are the definer of what a holder of record is. And if they change it, then all of the other consequences could come up, including triggering 12G. And you might ask, well, why would they want to do that? And if you're paying attention to what the SEC has been talking about recently, they are really concerned about, here's the private markets, they're huge and unregulated, and all of the companies are here, and here's the public markets, and they're not getting any bigger. And if you wanted to grow this one for transparency, you would just pull some companies over from this pool into this pool. And how would you do that? You could just change the definition of holder of record.
Interesting. So there could be changes coming, but we've all been waiting for those. But the reality is we have to live with the rules that we have. So, I mean, there are scenarios, and maybe some here are listening. So let's talk about some scenarios without talking about companies. So here I am as a company. I've done 2 Reg CFs. I've done a Reg A. I've now kicked it in. What are my choices? What am I looking at right now? I got a 2-year window. As you said, I have to maintain my filings. What are my 2 options that I need to consider to, I don't want to say the wrong word, but I want to say the word navigate to make sure that I do either one compliantly. Who wants to go first?
I can. Okay. So I mean, here is a really, really interesting question. I mean, once you have triggered the 2-year period, and assuming that you have not managed to accelerate it by making one of your filings 48 hours late, for example, then you have 2 years to file, and that's sort of 2 years from the trigger point. Here's a really, really interesting question, because in the traditional world, you just trigger the 12G and you've got 128 days. There is no grace period in the non-Reg A, non-CF world. So you've got 120 days. So this issue does not come up in the traditional world, but in the Reg A world, there is the possibility that you have raised an enormous amount of money. You've gone over your 25 million. You're sitting on 26 million at the end of your fiscal year. You start working on whether you're putting together all of your future filings. You're deciding whether you're going to have an audit committee and all of the bits and pieces that go with being a public company, and you've engaged PCAOB audit. But in the meantime, you've been spending your money down. So at the end of the first fiscal year after the trigger, you are now below. And let's say you're below the 12G triggers altogether. You've spent all your money and you only have 299 shareholders. We have gone to the SEC and asked, is it possible to regain your 34 Act virginity by not having enough money? And we are waiting for that answer. So depending on the answer to that, if you know that the 2-year period is definitely for sure going to do, and there's nothing you can do about it, like, for example, get your shareholders below a certain number, then you should absolutely be doing 2 things. Making sure you're doing all your Reg A and Reg CF filings. You're not going to accelerate yourself. You should be engaging or talking to engage a PCAOB auditor. You should be talking to law firms like the ones represented here about what is it going to cost, how do we do it in the most painless way possible. But the one thing I would say is the SEC is in favor of having people become reporting. If you manage to sort of like make your filing, and you make the filing under 12G on Form 10, if you file Form 10 late, what are they going to do? are they going to say, well, we're not going to accept it because you were 5 days late, either after the 120 days or the 2 years? It's in their interest to get you to the point. They might yell at you, but they're not going to say, well, now you have to go back to the private markets and you can't be a registered company. So I think the bottom line of this very long spiel is don't panic, but do start talking to people about accounting and law.
And that's a moving forward there, but the company still has to find a way they need to make a decision. They're either going to become a reporting issuer and make sure they got all that set up with lawyers, the auditors, make sure they have the teams internally ready for that. That's one approach. And then, of course, there's another approach they can try to attempt. That's not to evade. I don't want to use that word. I know that's a cautionary word, but where they can work with their partners to see if their shareholders voluntarily, because it has to be voluntarily, right? Shareholders would voluntarily have to agree to be, I don't want to use the word place, but to agree to go into a custodial element in order to sit as one shareholder in the company.
Right. I would say, though, that that decision has to be before you trigger. Once you trigger, you trigger. And so the decision that you're going to make about, because one of the things you could do is you could just spend all your money so that you come down below, 25 million. Give it away. Give it to me. That's fine. I'll help you. But that decision, and unless the SEC says, you can untrigger, you can regain your 34 Act virginity that way. Unless they say it, and they have not said that yet, that the decision you're talking about, Oscar, that has to be made before the trigger occurs.
Because I think if you try and make it once, that's almost, essentially it's a scheme to try and evade the application of the security clause.
Yeah.
But that's a very interesting distinction that you just, sorry, Patrick, I didn't mean to cut you off. I just want to make sure everybody got it. Is that the only time you have that decision to make if you do it before it triggers. Once it's triggered, it's triggered. You're in the 2-year window. There's no way out. Now it's all about preparations.
That's right. Unless the SEC comes back to us with a different answer, because here at CrowdCheck, we are absolutely split. A couple of my colleagues think that if you go down below the threshold, you should have the benefit, and I think triggered is triggered, but we do not know the answer to that.
And it's certainly an interesting argument, because if you are required to register no matter what when you trigger that, and there's nothing you can do to change that, the statute says 90 days after you fall below those 300 holders of record, or I think there's another one, but I'm blanking on it.
I know what you mean. Yeah.
Yeah, that is the counter argument, right? That you're making us automatically register. Maybe we automatically unregister. But
that's my colleague Jamie's argument. Yeah.
I like.
So does that mean we go back to the SEC and say, hey, so
we are waiting for the SEC. We are not the only law firm who's approached the SEC asking for an answer on this.
Okay.
And as I say, it's new to this market, because you don't have this situation in the traditional markets. It's trigger and then 120 days.
Yeah.
So you don't have intervening trigger dates.
I want to come back to just because, again, the responsibility is on the company to make sure it doesn't get triggered. How will they know? It came to me as a surprise lately. I'm now educating myself. But how do I know as a company? Who am I training internally in the company? Is it my legal team's responsibility who did my filing? Is it my CFO internally? How does the company monitor that, right? It's sort of like, oh my God, we're getting near. How does anybody know?
I think Sorry, unless you have, you would like to go. I think that one thing you can do is having a transfer agent that is keeping track of the shares that, and the issuances and the transactions in those shares. You'll be able to, now, if you have multiple classes and the transfer agent's only the transfer agent for one of those classes, this isn't a foolproof solution, but it does give you a way where, okay, investors and shareholders have to go through the transfer agent in order to either, dispose of their shares or obtain their shares. So there is a clear record with having a transfer agent of the amount of shareholders that you have of that class.
Okay, so the transfer agent knows, but the transfer agent doesn't know the value of the assets of the company.
No. I mean, this is essentially a responsibility of the company and how the company chooses to monitor. I mean, it's not something lawyers are going to know because they're not going to. And at some point, they might come to do the annual 1K filing and look at the balance sheet and go, "Hey guys," and then also look at the revenues and go, have you been paying attention? But somebody in the company has to. I mean, this is one of the things about the online exemptions. You are creating a huge amount of regulatory complexity much earlier in a company's life than used to be the case. And so somebody in the company needs to pay attention. CFO, general counsel, but they should have a policy.
So is it a policy? Does it need to be monitored like quarterly? Like how would you?
Yeah, I would say as you get towards within a couple of months of the end of fiscal year, but you should know at any given time what the triggers are and how many shareholders you have. I mean, really, you do have to know those things. But the assessment, I would say, put in the company's standard processes, assessment as to 34 Act compliance, on a regular basis.
So but the exemptions allow you to have more than 500 holders. But if you exceed the underlying asset, that's the only tangible that needs to come from a CFO regularly coming in. Hey guys, our assets are at 15 million. Next year projected we could hit it. That's the trigger point. That's when it becomes.
But remember that there's sort of like several different. There's the base asset test, which is the 10 million. Then, with respect to the Reg CF, there's the 25 million. Because one of the things that's happening in this market is you've got the Reg D issuances that you did in the early days of the company.
Correct.
Then you did a Reg CF. Then you did a Reg A, and any one of those could end up, assuming that you've issued the same class of shares to any of them, any one of those could end up triggering the 12G requirement, even though you've still got the exemption under the others. And we've seen it more. I mean, the thing that we've seen most is that 25 million. Typically among companies who did a D, then a CF, then an A, and now at some point they're just sitting on 25 million, and now their Reg A investors are not a problem. It's their Reg CF investors. So that's where we've seen it most frequently.
It's that investor that's causing, I don't want to say causing the issue, but it's the thing they didn't plan for.
Yeah.
And that's all capital planning. I mean, I think what I liked about this discussion today is that 12G was an afterthought a few years ago. Sara, you and I talked about this, and Patrick, I'm sure in your firm and others, it got brought up, and nobody worried about it because there was no examples. Today, we're facing these dilemmas with companies, and to the point of Sara doing a Reg D, a Reg CF, and a Reg A, and now I'm not saying scrambling, they're planning with all their professionals, but that planning should have been done preempted. And now going forward, what I did here, which is really good, just a reminder for any of these companies doing Reg A, Reg CF or Reg Ds in the Jobs Act, is to make sure that your CFO is providing you constant information on the value of your assets, so you understand where the triggers are. I think that's it's like everything else. These are the benchmarks. This becomes a benchmark now, and into moving forward. But again, so I heard Sara, I think you're for. Patrick, where do you sit when a company gets triggered? Do you think the company should be allowed to go back, or do you think the company should be triggered and begin full reporting with the SEC? What are your thoughts on that?
I think they should be allowed to go back.
Okay.
I think that as a concept, Section 12G maybe made sense back after the Great Depression and then the crash of and everything that was going on back then when it was originally promulgated. I think that now having a section that requires issuers to register and that those registration statements can go effective automatically, I think that is completely antithetical to what the SEC is supposed to do. They don't even have to review those sections in order for them to become, those registered companies. And let me tell you, I remember from my time at the SEC, there was a process where in some states you can obtain a conservatorship or guardianship over defunct reporting companies and bring them into compliance under and register their shares under Section 12G.
Wow.
And let me tell you, those registration statements were not great. The disclosure was lacking. And I remember my immediate supervisor at the time would tell me, yeah, like about, I don't know, it is what it is. We don't really have the resources to review these things, and you shouldn't spend much time on it. And it's like, what are you doing? What do we do here? So no, to answer your question, I think
that's fair. So Sara, I'd like to hear yours. I mean, you and Patrick share a common background. You've been on the other side a little bit longer than Patrick, but you have a different view.
Yeah, I am team triggered is triggered. And so, my position, if I were making this policy decision back at the SEC, it's for reasons of certainty and arguing certainty in favor of registration. That's where I would end up. But
okay,
we are waiting here.
Yeah, we're waiting. But I'm looking at the positive side. So the positive side of reporting, it just means the company is doing additional filings, and some would say, well, that's additional cost. Well, I'm going to put it this way. I look back when the regulations first came out, what it costs, what it is today. And it didn't just go down 5%, 50%. It's like gone down dramatically, where even a brand new company can get engaged with Reg CF or Reg A immediately. Mm-hmm. So I think we need to understand what it means. So I'm with Sara. I know this is going to sound really weird. And I'm a private company, and I think what this would do, this is just me, it would force a brand new component of our ecosystem to come out with technology and tools to make it more efficient for people to do things. I'll say this for you in the legal community. You've done that wonderfully for Form C and Form 1A and other things that people need to get it. You've done it in such a cost-effective way. And then the rest of the industry, the broker-dealers, and the way they've adopted technology for people to invest online very seamlessly. I think this is just another evolution of it. We shouldn't fear it for the mere fact that they've crossed it. We just need to embrace it, and then the company has better opportunities going forward. I know that there are going to be those exemptions that should have never even gotten that far. But there are companies who are generating revenue, who already have assets. I firmly believe they should go through the process, because then you start asking your question is, what do you got to hide at that point? I mean, that's just me. What do you got to hide? I mean, if you're operating, you're win. I mean, eventually, is it a competitive advantage? Nobody's saying to leaking out competitive information. I mean, public companies have competitive advantage. Look at Apple, look at Microsoft, all of them. They have their trade secrets. They do it as a publicly traded company. Google, Tesla, every one of them. So I think that argument for me is that so that's where I sit with this. This discussion with 12G today is I think we all need to start putting it in front of every discussion before the client gets engaged. That way they have a playbook saying, hey, I need to look and understand this to make sure that I'm properly structuring myself with this offering. And when it does happen, I'm ready to go. I'm not fearing it. That's just me. I firmly believe that we're on track with that, because if David Weil was on this call, he would say that divide between the private and the public, and Sara just said it, where is that transition? And whether it's an acquisition, think about being acquired. If you want a public company to acquire you, you're going to have to meet their requirements anyway. So what we're trying to really do here is just enhance the private markets. So I'd love to hear your last comments on this, Patrick.
I think it should be a choice, right?
Okay.
I think that and that's not to say that I think that 12G should, necessarily go completely away. I think it makes sense where at a certain point you become too big. You have too many shareholders where you should have to put out some disclosure. You should have to disclose things about your business like you're a public company, because you may be a public company in a sense because of how many shareholders you have. I think that really where I come in is if, it should be easier than it is now. And I think that it should be a choice to go back from becoming that exchange act. If you can get your shareholders to agree, you can get them to, if there to be some way for that to happen, I think that would make the most sense for me.
Sara?
I am very much in favor of companies coming to the public markets, and I am in favor of the public market reporting requirements being scaled to be appropriate for small companies. I mean, what I would love is if you could take the Reg A reporting regime and say, we create a new class of teeny tiny companies, even below the nanos and the small accelerated and all of that stuff. We create a tier of really, really small companies and say for them, Reg A works.
I think you could achieve that by exempting it completely, right, from 12G.
I think that I think that you could just have a variations on, that you could have the mini 10K, which would basically be I think you could do that from a regulatory as opposed to statutory point of view. Not going to happen in my lifetime.
Hey, don't say that. Nobody's thought that we would have this in our lifetime, and we do. We have to be thankful, and it's good that we have these discussions, because then we're opening. Look, I look back where all this got started. We were just talking about how to invest, how to make it happen, and it's evolving. It's evolving better and better every year. Yes, we're going to stumble and make mistakes, but I think I don't treat this as a mistake. I treat this more of an awareness. It's like anything else. When you're incorporating your company, you go, should it be a C Corp or an LLC? There's pros and cons, but you have to understand the business model. And you go, you know what? The LLC is the best way to go for me versus. So I think this is one of these items until the SEC hears more from us, from the industry, as to what's going better. But so I want to thank both of you. Thank you so much. Okay. And helping us close the year with a very, very interesting topic for those companies that you feel you may be near these thresholds, both from the shareholder and the assets. I encourage you to reach out to Sara and Patrick. You can find their details at KoreSummit. You can see all the speakers. Their contact details are there. You can reach out to them on LinkedIn. The important thing is to get that discussion going early, because you heard from them. Once you get triggered, it begins. It's always good to have the discussion in advance so you can view which way to approach, and so you can best prepare. Until next time, everyone, and in the new year, wishing you all an amazing, amazing holiday season. I want to thank everyone for 2023 who participated in all our core summits, our sponsors, Nuvei, and of course, all our core partners who've been participating in making this happen for all of you. And I hope that in 2024, we'll see you back again. Until then, Sarah, Patrick, we'll see you soon. Take care.
Thank you.
Thank
Bye.
you.